You know, every country has its ultimate rulebook, right? Its foundational documents. But what happens when that rulebook, written decades ago, needs an update? Well, today, we're going to dive into the fascinating way India, the world's largest democracy, goes about changing its own constitution. It's quite a story.
I mean, really think about that for a second. How do you edit the very document that defines a country, its rights, its powers, the whole shebang? You need a process that's flexible enough to let the nation grow, but also really, really tough to stop people from making reckless changes on a whim. And right there, that's the real heart of it. India's constitution lays out a clear path for making changes. But, and this is the crucial part, the Supreme Court has basically drawn a line in the sand, a line that says this far and no further to protect the very soul of the document. So, where are the instructions for all this? Where is the how-to guide? Well, the answer is tucked away in one very specific, very important part of the Constitution. Let's take a look. And here it is, Article 368. Honestly, you can just think of this as the Constitution's official edit button. It's the part that gives Parliament the power to make changes. And more importantly, it tells them exactly how they have to do it. This is the engine room for any constitutional change. Now, what's so clever about this is that not all changes are treated the same. The framers were smart. They created a system with different difficulty levels. It all depends on just how fundamental the change you're trying to make is. So you've basically got two different worlds here. On one side, you have changes that are pretty routine, stuff that gets passed just like an ordinary law, totally outside the strict rules of Article 368. And on the other side, you have the really serious amendments, the ones that have to clear a much, much higher bar. So let's start with path one, what we can call easy mode. The key thing to get here is that these changes are so routine, they aren't even officially considered constitutional amendments under Article 368. Think of these as like administrative tweaks, things like creating new states or updating citizenship rules. Important, but not earth-shattering. Okay, now we're leveling up to hard mode. This is the go-to method for most major constitutional changes, and it's like a two-part lock. First, you need more than half of the total number of members in the House to vote yes, not just half of who's there that day. And second, of the people who are actually present in voting, you need a supermajority of 2/3 to agree. You have to clear both of those hurdles. And finally, we get to the highest difficulty setting, co-op mode. This one's reserved for any change that messes with the federal structure. You know, the balance of power between the central government and the states. For these, not only do you have to pass with that hard mode special majority in Parliament, but then the bill has to go out to all the states, and at least half of them have to approve it too. It makes sure the states get a say when the fundamental power-sharing agreement is on the table. So Parliament has all these powerful tools, a simple majority, a special majority, even a way to get the states on board. It kind of makes you wonder, is there a limit? Just how far can they go? Is there anything they can't change? And this became a huge question. There were times when it felt like Parliament was chipping away at fundamental rights, trying to limit the court's power. It led to a really scary thought. If you just follow the right procedure, could you technically amend the Constitution to, I don't know, get rid of democracy itself? And then, in the landmark year of 1973, the Supreme Court of India stepped in, and it gave a very clear, very loud, and very powerful answer to that question. This single sentence from the legendary Keshavananda Bharati case changed everything. It was a thunderclap. The court said, look, you have the power to amend it, but you do not have the power to destroy it. It's like saying you can renovate the house, but you are not allowed to demolish its foundation. And this powerful idea became known as the Basic Structure Doctrine. It's not written in the Constitution itself, but it acts like a judicial firewall, protecting the core identity, the fundamental DNA of the Constitution from ever being erased. Okay, so what exactly is this basic structure? What are these foundational pillars that are supposedly untouchable? Well, over the years, the courts have given us a pretty good idea. The list includes the absolute essentials of a modern democracy. Things like the supremacy of the Constitution itself, the separation of powers between the government branches, federalism, secularism, and of course, the power of courts to review laws. These are the non-negotiables. All right, we've covered the different paths and the ultimate limit. Let's just quickly run through a few key procedural rules that are really important for understanding how this all works in practice. This table breaks down some really crucial details. First, unlike a regular bill, the president must sign a constitutional amendment. No veto power, period. Second, if the two houses of parliament can't agree on an amendment, the bill just dies. There's no joint session to sort it out. And finally, remember the states only get involved in federal issues. And weirdly enough, there's no time limit for them to make up their minds. And one more really important point. Unlike a lot of other countries, there is zero provision for a public vote, a referendum, on any constitutional change in India. The power lies completely with the elected representatives in parliament and the state legislatures.
And that really brings us to the final fascinating question. The basic structure doctrine, this ultimate safeguard for the Constitution, it's not actually written down in the Constitution. It was created by judges. So that leaves us with this incredible, ongoing debate. In this constant dance between Parliament's power to change and the Constitution's need to survive, who really gets the final say?